having the Thursday meeting of our Judiciary Committee of the House, and to begin with, I'd like to first of all welcome our new esteemed chair of the Senate Judiciary Committee, Senator Josh McCoon. And Josh, Senator, we're very pleased to be able to have you come by and say hello. He had me come to his committee earlier this week and say hello, and asked me to come by and do the same with our committee. As I expressed the other day, we've had a great relationship working in the past with Senator Hamrick when he was chairing, and I'm sure that's going to continue. Josh and I have known each other for the last couple of years. I know Josh to be a hard-working member of the legislature, and we've got things coming through here, and you're going to have from your side that we can sit down and talk over, and I'd like to have you address the committee, if you would. Let me get you a microphone. There you are.
Well, thank you very much, Mr. Chairman. I appreciate the opportunity to be here with you today, and I know you all have a busy agenda. I'm not going to take very much time other than to say thank you for the invitation. I look forward to working with the members of the committee and with you, Mr. Chairman. I appreciate the good dialogue and communication we've already had, and that I hope we'll continue to have through the session. And if I can be of help to you or to any of the membership, my door is open, and look forward to working well over the course of the next couple of months.
Well, thank you. We're glad to be able to have you come by and be with us today. So we'll certainly be working closer together.
Thank you very much.
Thank you too, sir. We have several items on the agenda today. We have 4 bills. The first one will be House Bill 175 by Representative Hightower. And if you're located, Mr. Hightower, you come around. We're pleased to have you today, and I think we've got a sign-up sheet. No one has signed up for this bill. Is there anyone who would like to sign up for any of the 4 bills? Please do use the sign-up sheet so we'll know you're here and can call upon you when time comes. Yes, sir. Let's look in here and be sure we got the right bill. You've got 2. I'm looking at 2 different copies, and we have one that's identified LC 295445S, and the other is LC 295452S. Which one will we be working with? You identify it?
Yes, sir. We had a committee substitute that came in. It's LC 295445S.
Okay.
The other substitute is one that we may take up at the pleasure of the chairman if there's someone who'd like to speak towards that. But
all right.
Did you sign up to speak towards that? But right now we'll start with that one. And
all right. Let's start with that. Then we'll see what your substitute does.
Okay.
Tell us about your
I greatly
bill.
appreciate you allowing me to come before y'all today and present this bill. What this does, this simply codifies what much of our current case law states. If you look at this, when it references except as provided in Code Section 44-5-60, that code section specifically deals with covenants and how they work. Right now, I've had a constituent and a judge and then a couple other people that have come to me with saying that case law simply says overall that covenants that are properly filed should run with the land. And we all can understand that when you have subdivisions or other areas, when a covenant is placed in, we want to make sure that covenant does stay with the land, it stays uniform. That code section that's referenced here also says that most covenants will stay in place for 20 years, and then after 20 years they'll automatically renew. What this does is this simply codifies with what most of our case law says. Right now it's not codified anywhere really that the public policy of Georgia is that covenants do run with the land. We're not really changing anything here. We're just codifying what case law presently says. There are a couple of exceptions to that rule, but they are usually very minor and very particularized exceptions. But the overall public policy for most case law you will see does simply say that covenant should run with the land, and that's what this says. And I believe Ms. Travis, if she wants to say anything more than welcome to.
Ms. Travis, you got any comments? Nope. No follow-up. All right, we're going to, if you will, Representative, let me get some members who'd like to ask you questions. I think we have the first one is who? Mr. Welch? Is that yours? No, yours. I'm sorry, Mr. Powell. Beg your pardon.
Thank you, Mr. Chairman. Tell us what the difference between the 5445, which you are presenting, and 5452, because it seems to me that 5452 might do away with some ambiguity, because if you say that covenants run with the land if they are between two parties, and there are some that do not, then that could imply that those are not covenants running with the land. And it seems like 5452 addresses that issue. And so do you have any feeling one way or the other about the desirability of adding that language in 5452?
I'm completely fine with adding the language in 5452. In all honesty, procedurally, being new to this, I thought that procedure would be more appropriate to go with the committee substitute that came out of committee first. And then I had this substitute of mine drafted after I spoke at length yesterday with a couple of attorneys that specialize in only covenant law. They had presented LC 295452's language by adding that sentence at the very beginning, because they thought it may clear up some ambiguities. I have that substitute ready if everyone would like to go with that one.
What is being added, I mean, interrupt, but what's being added is after the code section 44560, that next phrase, and excluding covenants recorded on property solely by the property's owner, singular property's owner.
That is correct, Mr. Chairman.
Okay, so that's what's added in there.
Yes, sir. And it
also says which shall run with the title to the land. That next phrase too.
That's
okay.
Correct.
So you got two different phrases there. All right. And then it picks up with what you had of the rest of your bill.
That's correct, Mr. Chairman.
5445. Everybody understand that? Those two phrases. All right. Thank you.
And I believe it may go to clearing up a few ambiguities, and that's why we had it drafted. And if the pleasure of the committee is to go forward with 5452, we're completely on board with that. That's why we had that language drafted. I believe it may actually clear up some questions and concerns for folks. So if the pleasure of the committee is to move forward 5452, I'm on board and understand the necessary need for it.
Anything further?
Yes, sir.
Ms. Evans.
Thank you, Mr. Chairman. On both of these, you have language that says it is the public policy of the state that, and I was wondering what's the purpose of that rather than just saying what the law is without that prefatory statement.
Just to give guidance when judges or anyone, lawyers are looking at that and needing a reference or needing a guidance point. Right now, the case law is very strong on the side that covenants do run with the land. And we were just codifying what the case law is, and what that is that it is our public policy that covenants do run with the land. So we're stating exactly what we were wanting to say.
One follow-up, if I
Yes, ma'am.
could. If we took out that language, it is the public policy of the state that, would it make a difference? I just think it might be cleaner. I wanted to just make that suggestion to you.
I think what I've read in the past, just put my own 2 cents about that. When you have something that says it's a policy of the state, it's usually doing something of a prohibition. I think of, I don't know what you'd say as a policy state, as a matter of statement of law. You know, certain types of conduct would be prohibited as being the policy of the state. What do you think, Ms. Travis? You sit there and come up with an answer for me.
As I recall, Representative Hightower was working with another lawyer that was involved in this, and the language that was brought to him and forwarded to me had that language in there, so I put it in there. I'm sort of tending to agree with Representative Evans that I'm not sure that it really makes a difference. You're passing a law. Obviously, you're making it the public policy.
Yeah.
All right.
Correct.
Thank you. Anything further, Ms. Evans?
You have a suggestion on how to just either mark it?
We'll ask you questions. We'll get to it. We'll get to the discussion on the bill in a minute.
Okay.
Any other questions of the presenter? You have anybody want to talk about this 5452 52S as far as this added language and what is the shortcoming we have or deal we're trying to cure with it?
Yes, Mr. Chairman, Julie Howard, please come
up, Ms. Howard. Y'all can sit together if you want to. We got 2 mics.
Good afternoon. Thank you for your time. I'm Julie Howard. I am an attorney. I'm a partner at the law firm of Weissman, Nowak, Curry, and Wilco. And my practice for the last 18 years has been dedicated solely to representing condominium and homeowner associations. And as part of my practice, all I do is write, review, enforce, interpret covenants. So I have been working with Representative Hightower to clarify what my partner George Nowak and I believe would help with the enforceability of this law should it be passed. And typically a covenant that's recorded against property is done so unilaterally by the property owner, and there's not typically an agreement between a third party or consideration when a covenant's recorded. And so our concern is ensuring that if this were adopted, that it wouldn't be exclusive, that it wouldn't require that there be consideration and a third party in order to have a valid covenant. And for that reason, we had suggested the addition in the modified bill that you have this afternoon. And otherwise, on behalf of, as a lawyer practicing community association law, and also I chair the legislative group for the Community Associations Institute, I can say that we would otherwise support the bill with that addition to provide clarification.
Questions? Ms. Howard, you and I were having a discussion. I'm going to bring it up this time so we can get others' input about it. To me, it is, if not explicit, it's certainly implicit that you start out with a covenant usually with the land being recorded by a single person. Because wherever you have a covenant to be applied to land, if you got multi-owners of it, all the owners have to sign it to have it to be effective. Point being, if you had 3 owners of a piece of property jointly owning it, and they're going to put covenants on it, you couldn't have one person sign it and have that covenant effective. Possibly, but
well, in the context of a community association, one owner might be able to bind multiple owners.
Just like we talk about someone who's going to develop property, divide up into lots, divide up a condominium, there's a single, usually owner or a single entity owner, and they, as a start, say, I'm going to put covenants on this property, so as I sell it, now the covenants become binding because they can be enforced by each person who buys into that large tract where the covenants have been recorded. So all we have here is just a words of saying what is already, certainly if not explicit, is implicit in the law. You can't have covenants until they start out by one person usually recording them.
Correct. And as we talked about, 44560 already states the law in subsection A, that covenants run with title to the land are binding on the purchaser, and the law of servitudes in the state already provides for that fact as well. And so by adding this to the law that already exists, we want to make sure that there's no confusion that a single property owner or whoever's on title could agree to unilaterally record covenants, and there is no requirement that there's consideration or an agreement with any third party like you might have with an easement. I mean, you would have an easement or a license recorded where you would have a third party agreement.
Right. And we're saying even without this being recorded, that is already what's recognized law, if not by statute, certainly case law, that you start out with a single owner with the recording of covenants, then others buy into that area of property and they become parties who can enforce it, right?
Correct. They become bound. But since this language doesn't actually address the enforceability, but just the binding nature, that's what we're trying to clarify. We want to make sure that there is no confusion should this be adopted.
All right. Anyone have any questions of Ms. Howard? Well stated. Thank you, ma'am.
Thank you very much for your time.
And thank you. Is there anyone else who would like to speak to House Bill 175 here today? Please come forward. Ms. Calloway.
Thank you. Mr. Chairman,
You want to sit on the, would it make you more comfortable in the corner there? I can get you the mic on. All right. Great. State your name for the committee and who you represent.
My name is Diane Calloway, and I represent the Georgia Land Title Association and various other even larger land title associations, but I'm here about the Georgia Land Title Association. I'm sorry to spring this on Representative Hightower, but it's, I think, for the common good. My only request, and the chairman knows what my field of practice, it's been title law for about 30 plus years, and I would like to add some some clarifying words like duly recorded instrument, found in the applicable chain of title. That's the only thing, because right now it could be an inappropriate instrument, but I wouldn't want to say that just because it appeared in the deed records it would bind people. It's just a matter of adding a word or two. Duly recorded and found in the applicable chain of title. Ms. Travis, I don't know if you think that that would add anything to it, but maybe some of the property attorneys around these parts might go with that sentiment. I'm sorry I tried to talk with you earlier, but so, Mr. Chairman, that's my 2 cents.
All right. Any questions of Ms. Calloway? I don't see any. Thank you, ma'am.
Thank you, Mr. Chairman.
Is there anyone else who would wish to speak to the committee? Pardon me. If not, we will close off public input, and the House Bill 175 is in the breast of the committee. Any comments, discussion among committee members before we consider the bill? If not, the chair will entertain a motion. We have a move do pass. Is there a second to the motion? It's been seconded. Is there any amendments to be offered to the bill? I'm sorry. Good. Let's back up. Make your motion as to a specific draft, since we got 2 of them, if you would, Mr. Fleming. All right. So we're looking at the motion is on 5452S. The motion is do pass. And do we have a second? Second on that? Any discussion or amendments? Mr. Bruce, did you have your button? Ms. Evans, excuse me. Can't always tell.
That's right. I offer an amendment on lines 11 and 12 to delete after land comma delete. It is the public policy of this state. That. Yes, thank you.
There's been a motion made. The amendment is on lines 11 and 12 at the end, starting, it is the public policy of this state that be deleted. And that's been seconded. We'll take up that amendment first. Any discussion on the amendment? Not, the chair will call for a vote on the amendment. All in favor signify by saying aye. Aye. Opposed, like sign. Are there any other amendments to be offered? The chair is going to, let me look at something. I want to make a proposed amendment. The chair will propose on line 12. We have struck down through that. After A, insert duly recorded instrument, or duly recorded covenant, excuse me. To answer what Ms. Calloway.
Maybe in 13, before recorded, would be a better place.
Okay. So you want to put duly recorded or properly recorded? Duly. All right. On line, the amendment will be on line 13, reflected in a, then duly be inserted, recorded instrument. Chair will make that motion. Second it? Yes. Any discussion on the motion? Chair will call for a vote on the amendment. Amendment is to insert the word duly. All in favor signify by saying aye. Aye. Opposed, like sign. Motion carries. Any other amendments?
Mr. Chairman?
Yes, sir.
Following that same train of thought, after instrument, I would add found in the applicable chain of title.
All right. The motion is to add after instrument found in the applicable chain of title. Second. Correct. There's a second on your motion. Any discussion on the motion for amendment? Not the chair will call for the amendment. All in favor signify by saying aye. Aye. Opposed, like sign. Motion carries. Any other proposed amendments?
Mr. Chairman, may I ask Ms. Travers for
Yes. Bring your mic around, please.
Is there any consequence to the fact that we've said duly recorded instrument found in the applicable chain of title when we're talking about covenants on 12 and 13, and we don't do the same thing in line 10? Is there any consequence to that? I mean, I don't want it to get so wordy that you can't read it, but
I think your thought is the first phrase is covered by the fact that now we talk about a recorded covenant, even by a single property owner, has to be duly recorded instrument as found in the chain of title. Does it not?
I don't know. That's what I was asking Ms. Travers. I didn't know the answer to the question. What if I...
Pardon? Hold on. Yeah, let's second.
Since line 10 is talking about excluding a covenant, whether it was duly recorded or within the chain of title, if it's excluded, it's excluded no matter what. Would it not be? If it's a good one, you exclude it. If it's a bad one, you exclude it.
All right. Good point. You had a question over here. Was it you again? Are you through, Mr. Powell? You're happy. All right. Any further amendments? If not, the chair will call for a vote. It'd be a motion. The original motion is a motion do pass now as amended of LC 295452 as a committee substitute. All in favor signify by saying aye. Aye. Opposed, like sign. Motion carries. We got your bill. All right. Moving right along, I think the next bill was... Who's having to leave? Was you, Mr. Powell? You don't have to leave, do you?
I can.
No. Hightower. I know I got his bill. I thought somebody said... Mr. Geisinger, you're up. I think you've got a group here, so we'll call on the H.R. 4, a resolution proposing a settlement of the boundary dispute between the state of Georgia and the state of Tennessee and for other purposes.
Mr. Chairman?
Yes, sir.
Thank you, sir. Since technology is not what we think it should be, and it's hard to
Oh, I'm
see
sorry.
exactly...
Why don't you pull that microphone to you?
Thank
there.
you. It's hard to see exactly what the proposed area is. I brought this for you all to look at, and you can see it clearly on this.
Might put some bottles of water or something to hold it down on the end
Yes,
there.
let's use water since that's what we're after.
Something to open it up. There we are. Better put it on that side. Okay.
Well, that's
Please.
because of the gray heads, Mr. Chairman. I understand. Thank you, Mr. Chairman. Little history. 5 years ago this month, we were before this committee and brought a resolution that passed overwhelmingly in the House and Senate, which called for the state of Georgia to challenge the entire boundary, because historically when Georgia gave up, and by the way, Georgia used to extend all the way to the Mississippi River. In its founding, when it gave up the Mississippi Territory, it was agreed with the federal government that the line would run from West Point, Georgia, northwest to the northern bank of the northern bank of the Tennessee River at Nickajack. Well, in 1818, because there were a lot of settlers that weren't quite sure where they lived, the governor of Georgia got two surveyors, one a Georgian named K-Mac, who was a professor at the university, by the way, in mathematics. And he and a Tennessee surveyor went to put the mark exactly where it belonged, at the 35th parallel north. Now, one of several things happened, because that was 195 years ago. We're not sure what happened. But basically, they put it a little over 1 mile too far south. And for the last 195 years, it's been 1 mile too far south. Now, when you realize that the citizens of Tennessee have no income tax, and Georgia has a 6% income tax, and we're talking about taking in 68 square miles, there's a lot of people that live in that area, and they don't want to become Georgians. They think they're Tennesseans, but they really aren't. So we're more interested in the future of the state of Georgia and the Southeast than we are worrying about those citizens. Consequently, what I'm proposing in this legislation is that we take about 1.5 square miles, put the mark where it belongs at the 35th parallel north, and give by law the rest of the land to the state of Tennessee, which they keep claiming is theirs anyway. That way, those people aren't going to be paying taxes. They're not going to be complaining about us. And we will get what we want, and that's the water, because the Tennessee River has 15 times more water than the Chattahoochee, and the Chattahoochee is being close to maxed out. We have an expert here that would like to also testify, Mr. Speaker, Mr. Chairman.
We'll get to that. Let me see if there's any committee members want to ask you questions about it. Anything you want to bring up? I want to ask you, what will the resolution do as far as making this matter go forward with acceptance on the part of Tennessee?
Let's assume that it passes as the one did 5 years ago, both bodies. Tennessee will have to take it up and pass basically the same thing. They may put some flowery words in it, but pass the same thing and accept that acreage. At that point, it will go to the United States Congress, and the House and Senate will concur with what we did, and it's done. Now, if we end up in court, and you saw what happened with the Chattahoochee River and the Tri-States water war, we've been at it for 20 years, and we spent millions and millions of dollars, and we still, maybe it's resolved, but I wouldn't stake my life on it. What this will do is very simply say we have not given up our riparian water rights, and we will be able to pipe water to North Georgia. And this is our future. This is what it's all about.
All right. Mr. Carver, I think you've been involved with the litigation background. I think it'd be helpful for the committee to hear from you or someone to tell us what has happened, what's transpired, where we stand now as far as the negotiation, litigation with Tennessee. Come on up. please. You can pull that mic down for us, if you would.
Mr. Chairman, members of the committee, Brad Carver, Hall Booth Smith, here to talk about this issue. I've actually been working on this for 6 years now, and let me see if I can minimize this. There we go. Just a real quick, I think that Representative Geisinger laid this out pretty well, so I'm just going to quickly go through the history, not only of our water situation, but also the litigation, proposed litigation, et cetera. Everybody in this room is very well aware of our water situation. The numbers are pretty bleak. We have about 15 years of water supply in Metro Atlanta and North Georgia. If you can see across the bottom, 2000 to 2030, the orange line is our existing supply line. If we build the proposed reservoirs, we can move ourselves out by ourselves maybe 5 years, maybe 10 years. And if you look at the purple line at the top, that would be if we allocated 26% of Lake Lanier and Lake Allatoona for water supply. That would be the best case scenario for the state of Georgia, and you can see where that brings our supply. Any of those proposed demand curves, the top being with no conservation, the green being the conservation measures that are in place now, and the bottom line being conservation measures going back to the draconian total outdoor watering ban, those types of measures, we can buy ourselves a few more years. But the bottom line is Metro Atlanta and North Georgia's water supply demand is going to outstrip supply in the next 15 to 20 years. The Tennessee River represents really the only realistic solution for a long-term water supply for this state. Other options like the Savannah River have been discussed, but again, everybody on this committee knows what would happen if we took water from the Savannah River. Obviously, we'd make our friends in the Augusta area very angry and in Savannah, but we're also dredging right now. We got a port expansion project going on. Taking water out of the Savannah River is not a good option. Not to mention units 3 and 4 of Plant Vogler are being under construction, and that's going to double water intake. So even though from a logistical standpoint, you could build a pipe in Rabun County and connect the Savannah River to the Tennessee River, it's not a good option for all the reasons I've outlined. The only other option that's out there to augment or bring water to North Georgia and Metro Atlanta is the Tennessee River. And the history of our association with that river is why we need to look at it as a 100-year, 200-year solution. Because the bottom line is if we don't do this, we are at a crossroads for the future of our state. And we will miss out on future economic development opportunities, future jobs, and frankly, water supply for drinking water purposes. Quickly, the Northwest Georgia area, one of the things that everybody that's been, I think, misperceived in this entire issue is that Georgia actually contributes 7% of the basin of the Tennessee River. So 1.7 billion gallons flows from the state of Georgia into the Tennessee River every day. And if you think about it, because Representative Geisinger's already said this, the Tennessee River Basin is 15 times larger. The flow volume at Lake Chickamauga is 15 times the flow volume at Buford Dam south of Atlanta. That means that there is more Georgia water flowing in the Tennessee River than there is in the entire Chattahoochee River. That's the magnitude of the water that's available. The other thing that's important to note, and I'm going to show this quickly. This is conceptually the plan. Obviously, we're working with an engineering firm. It's done a lot of consulting with us. But the plan, in a nutshell, would be to expand water supply in the entire metro Atlanta area. That would include the Lake Allatoona Basin, the ACT Basin, the ACF Basin. And in the ACF Basin, you also see the 3 dots here at the top. That's the proposed Glades project in Hall County. That is the Dawson. The first one on the left is the Dawson Forest project, which is the Atlanta property that's in Dawson County. That's actually a good site for a potential large-scale reservoir. And then the Calhoun Creek project, with actually Scott Cole at my firm is working on. Those three reservoirs could be, oh, thank you. These three reservoirs across the top, if we did a interbasin transfer from the Tennessee River, we could, in effect, drought-proof just about the entire state of Georgia. Because every major river, just about every major river in Metro Atlanta or in the state originates in Metro Atlanta. You have the Coosa up here, the Tallapoosa here, the Chattahoochee here, the Flint down here, the Ocmulgee here, the Oconee here, and all of these river basins would be augmented with water supply from the Tennessee. How much water is available? Well, before I say that, the thing that the way this is tied in is with these existing interbasin transfers we already have in place. Gwinnett County used to take over or 100% of its water from the Chattahoochee Basin and discharge it down here to the Ocmulgee Basin. Now with some return flows to Lake Lanier, that's been reduced, but there's still a significant amount of water that is transferring to this other river basin. Same thing is true from Hall County up here. We augment the Oconee Basin, and then down here the Flint Basin. So my point is, all of these river basins would get additional water flows. So everyone, the way this benefits the entire state of Georgia, first of all, it protects the Savannah Basin. The Savannah River wouldn't have to be used for water supply. And it augments all of the other river basins. So everybody downstream of Atlanta, the Flint River, the Tallapoosa, the Chattahoochee, the Ocmulgee, the Oconee, all get additional flows of water as well. So how much water is there? A reservoir operations study in February 2004 found that the Tennessee River has 1 billion gallons per day of excess capacity. And in fact, in this study, they went ahead and assumed a 264 million gallon a day transfer to Atlanta. And what I like to say is, when you take the lawyers and the politicians out of the room and you ask engineers, if you had 1 billion gallons of excess water, what would you do with that water? Well, it'll supply Metro Atlanta. They have more need than anybody else around. They're Metro Atlanta of 6 million people. So that's exactly what they did. They proposed a transfer to Metro Atlanta. Well, my argument would be we could probably ask for 500 million gallons a day. And that amount of water, if you remember my demand and supply curves, the entire Metro Atlanta area right now for 6 million people uses about 600 million gallons a day of water. We could potentially add another 500 million gallons a day and therefore guarantee and drought-proof our state for the next couple of centuries.
Let me ask you this question.
Yes,
I think we all agree we got problems with water here, and that's a solution. Where does it stand with what was done as far as a resolution back in 2008? What's been going on as far as negotiations, if any, and what is the position now?
In 2008, the joint resolution, which Representative Geisinger carried in the House and passed 137 to 24, and by Senator Schaefer in the Senate, and it passed 56 to 0. That resolution authorized negotiations with the state of Tennessee. Those negotiations took place by our governor, Governor Perdue at the time, and I was special executive counsel to him and helped him prepare for that. At that point, because there really was not something on the table to benefit Tennessee, they weren't willing to agree. So the point, or where Representative Geisinger come here is here to present to you today. This is a very sweet deal for the state of Tennessee. They would get to confirm the territory outside of where the water is. And in fact, not a single Tennessee citizen would be impacted if this were to go through. Georgia would get access to the river, and no Tennessee citizens would be affected. And from our standpoint, it gives us a couple of centuries worth of water for the entire state of Georgia. And at the same time, we wouldn't be impacting anybody negatively in Tennessee.
Do you have a map showing what we're talking about requesting
I do.
Let's take a look at that again and bring it up to.
Yeah.
I know you have it here, but is it one you put on the board or?
Let me.
Couldn't see mine.
I'm going to just quickly, Mr. Chairman. This is how it benefits Alabama. All of this additional water would also flow into Alabama. This is why we say this is really the Alabama, Georgia, Florida plan, because all of these states would get additional water.
Mm-hmm.
But to answer your question specifically, right here, this is the incorrect boundary. This is the true and correct 35th parallel. Right here, if some of you may have seen this, but Representative Geisinger and myself were on the History Channel, and Representative Geisinger did the narration. And I actually hit a University of Georgia golf ball into Lake Nickajack here. That distance is about 40, it's about 115 yards. It's about a 9-iron. Pitching wedge. But anyway, that's how close it is. And if you corrected it, what Representative Geisinger's plan is to give us this area right here, which there's no Tennessee taxpayers that are in that area. So no homeowners will be affected, but yet we would have access. And a better way to look at it is this. This is the aerial view. Yeah. Again, that distance is about 115 yards, and all of this would be Georgia.
It's just woods, national.
It's just
national
woods and
forest.
It's actually it's Tennessee Valley Authority property.
That's right.
And again, this area here, the light blue, would be Georgia's, and this is a very large, very deep water reservoir, Nickajack, and the blue part is technically Georgia.
Who controls taking water out of that reservoir?
The Tennessee Valley Authority does. It is they control all the reservoirs on the Tennessee River. They have, and so I do need to make that point. If this were to go forward, and this would be a interstate compact, which would be approved by the state of Tennessee and the state of Georgia, that has to go before the U.S. Congress for approval. If they do that, then we would be riparian forevermore to the Tennessee River, but we would have to at that point file a water withdrawal permit from the Tennessee Valley Authority.
So a lot of hoops.
There's still hoops to go. This is
All right.
another step in that direction, Mr. Chairman.
Thank you.
Yes, sir.
I think we may have some questions. I believe you're not asking questions. Over here we have Mr. Bruce.
I think it might have gotten answered. I was trying to figure out, the water's there now. And if we go through this, you're saying nobody would be impacted. What are they doing with the water now?
Right now, it's going downriver. And if you remember the flooding that happens in the Mississippi River Basin, again, we're in a shortage situation in the Mississippi Basin this year. But in previous years, we've had massive flooding of the Mississippi River. Every drop of the Tennessee River that does not go into the Tennessee-Tom Bigby waterway flows into the Mississippi River. So right now, it's just wasted. It's water that floods areas downstream. And frankly, what we would be doing is offering additional drought protection for all the downstream folks on the Tennessee River. They have 1 billion gallons of excess, and to be perfectly honest with all the members of the committee, the reason that they haven't been willing to settle with us is they like the fact that Georgia has a water supply problem. It is in their economic development interest for Georgia to have a water supply problem. So if we fix the water supply problem, then maybe we don't lose the Volkswagen plan 10,000 jobs.
It makes us more competitive with them.
Absolutely.
But if it's flowing downstream now to a place where folks downstream don't want it because it keeps flooding them, if this does not work out with Tennessee, will we be able to get the water once it goes downstream?
Well, the other option would be, because the Tennessee River flows into Alabama, it flows into Mississippi. The closest way for us to get it would be from Tennessee, and in fact, this Lake Nickajack that's displayed here, right after that map, or right after that location of the map, the river bends back south and goes into Alabama. And so that's when I say it doesn't impact any Tennessee citizens. What I mean is we wouldn't be making them Georgia citizens, so they wouldn't have to pay income taxes here, or in fact, they wouldn't be owing us all the back taxes that they've owed us all these years. But it also means that we're not impacting Tennessee citizens downstream either.
Okay. Mr. Fleming.
The Georgia resolution was
call you out of order.
By the state of Tennessee, not in a favorable way.
All right.
But I think that the other part of the resolution for 2008 is it did authorize action in the United States Supreme Court. And this action or this proposal is a way to avoid litigation in the United States Supreme Court.
Well, why hasn't that occurred?
Mr. Chairman?
Yeah.
In the legislation, the governor was instructed to sue if they didn't agree with what we wanted to do. And he didn't want to have two lawsuits going at the same time. We had the tri-state water wars going on. It was a matter of money.
Mr. Powell, you have pushed.
As I understand it, the public policy of the state is to prohibit interbasin transfers. If we were to pump water to Atlanta from the Tennessee River, would we then be required by our own policy to return it to that same basin?
That is correct. Under current state law, the Atlanta Regional Commission cannot plan for water resources to be transferred into the basin. And when we say that, it would pretty much means, because I showed you all of the river basins basically start in the metro Atlanta area, it means that the Savannah River is protected because of that legislation, but it also means that the Tennessee River is. So we do foresee that we made efforts in the last legislative session to amend the Interbasin Transfer Act prohibition to allow interbasin transfers only from the Tennessee River. And that way we protect all of our friends in Savannah, Augusta, and other parts of the state that don't want to see the metro Atlanta area siphoning off their water. So frankly, again, I think that this solution is a one Georgia solution. It is a way that we solve North Georgia's water problems without impacting the rest of the state, and in fact beneficially impacting places like Columbus, Albany, your area, Camilla, all of that area in southwest Georgia would benefit from this plan.
Judge, that's yours?
Yes, it is.
Pull that around.
Have we made any overtures to Tennessee concerning this proposal?
Yes, we have.
And could you tell me what their response or feelings may or may not be?
Well, the last conversation I had with the Senate Majority Leader is that this looks fairly reasonable.
Well, that's
because we're not doing what we tried to do 5 years ago, which was to take all their citizens as well.
right. I guess my point was that if we have not made overtures, I wouldn't want to show our hand until we at least had some discussions with them to see if they were maybe amenable to this before we pass this resolution, and then they'd say, oh, no, we're not going to do that either.
Well, let me say, if that were to occur, if they have a change of heart, that's fine, because when we take it to the Supreme Court, this makes our case even that much stronger.
Well,
actually, that was my point, to be quite honest with you.
Just to comment on that, the point is, I think that we as a state and parties to negotiations owe it to each other to make reasonable efforts to settle potential litigation. And I think that Georgia is making a very favorable. I'll be honest. When Representative Geisinger came to me this past fall with this, I frankly was not initially very supportive, because I think we're giving up a lot here. We're giving up Lookout Mountain. We're giving up 40,000 senators. I know Representative Evans is originally from that area. There's some. Lookout Mountain's a very valuable piece of property. So I think that Georgia's made a very reasonable offer here to settle this boundary dispute forevermore, as well as give us access to a river where they have a lot of excess supply.
Question I have, we've got this as a House resolution. Why are we not doing a joint resolution?
The Senator Schaefer said once we did it as a House resolution and sent it over, he was going to carry it. So it's
do one from their side, you mean?
Actually,
Separate.
carry ours.
I don't think you can do it that way.
Well, in the 2008 joint resolution, it was introduced. There was companion resolutions that were introduced in the House and Senate, and it was ultimately Senator Schaefer's resolution that crossed over and Representative Geisinger carried and passed. So it can originate in one chamber and go to the
Okay,
other.
but what Schaefer or the Senate will have to pass will have to be entitled, would it not, a joint resolution?
Mr. Chairman, I don't know the answer. The resolution that passed in 2008 was actually SR 822, and I understood it to be a joint resolution.
Yeah, it started in the Senate, but it was to be approved by both bodies.
By both bodies.
Yeah.
And that is the intent here. If it is not framed in that particular way.
Let's read down.
It is, okay.
It is read that way on the back.
That is our intent.
Okay. It was resolved by the General Assembly of Georgia. Okay. And this is be it further resolved that the clerk of the House. Okay. Yes, sir. Push your button. Hold on. Yes, sir. All right. We'll do the hard bills while you're gone. Yes, sir. Mr. Welch.
Thank you, Mr. Chairman. Representative Geisinger, thank you for the bill, the resolution, I should say. This does not authorize a lawsuit. Are we still proceeding on the 2008 resolution for the governor's authority to pursue a lawsuit if this proposed settlement isn't accepted? Is that what we're doing, or?
I don't believe so. But it was law. I assume that the current governor could, if we got a negative reaction, could go ahead and sue. Yes.
Okay.
He could do it anyway, I believe.
And just to add, the authorization in the 2008 joint resolution was to the Attorney General to bring forward litigation if it was not settled. And my understanding would be that authorization is still there for our Attorney General, the new Attorney General. It was originally for Attorney General Baker, now it's for Attorney General Owens.
Thank you. Any further questions of the presenter? If not, we appreciate you bringing this before us. Is there anyone else who would like to speak to House Resolution 4? I don't see any. No one in the audience. Will cut off further public input. The resolution is now in the rest of the committee. Do we have any discussion? If there's no discussion, the chair will entertain the motion.
Move due pass, Mr. Chairman. Second.
It's been moved and seconded for a due pass of House Resolution 4, which is LC 286429 as presented. Is there any proposed amendments? If none, any further discussion? If not, the chair will call for the question. The question is due pass House Resolution 4. All in favor signify by saying aye.
Aye.
Opposed, like sign. Motion carries. Thank you, Mr. Chairman. Thank you. We have two further matters. One is House Bill 194 by Representative Powell. The 171st is a bill entitled An Act to Amend Chapter 1 of Title 46 of the Official Code of Georgia relating to general provisions regarding public utilities and public transportation so as to provide venue for actions against gas companies. It's further to provide for related matters and to provide for the effective date and for applicability to repeal conflicting laws. Mr. Powell, you can keep your seat if you like. Do it from your seat.
Thank you, Mr. Chairman. I am operating off of LC 295443S, which is a committee substitute to HB 194. And what the bill does is currently the venue for electric companies and transportation companies is that they can be sued for torts or injuries that they inflict either in the county of their official situs or residence or in the county where the injury occurred. But they can be sued in the county where the injury occurred. If they do not have an office in that county, then they can be sued in the county where their home office is. Anyway, all of this bill does is adds to those two companies, which are transportation companies and electric companies, the gas companies, and gives them the same venue provisions.
How's the gas company defined? I'm sure somewhere defined. What is the definition?
It's defined on lines 73 through 78, and
there we go.
And it defines it as a pipeline or distribution system located in one county and having its situs or principal office in some other county, and a gas company that owns a natural gas pipeline or distribution system located in or extending through more than one county.
All right. Any questions of the presenter? No questions. Do we have anyone that would like to speak to the committee? Please come up and have a seat and give us your name. More than one?
Yeah.
Thank you.
Thank you, Mr. Chairman. Matt Sawhill, Director of Government Affairs for AGL Resources, which is the parent company for Atlanta Gas Light.
County Edge representing Atlanta Gas Light.
You know, first off, just thank you, Mr. Chairman, for the opportunity to be here. Again, this is an important bill for Atlanta Gas Light. We think it's a fairness issue for us. I'd like to thank our friends at GTLA for working with us to make, I think, this tighter language and applying only to venue. So I think our friends at GTLA just really were reasonable. We sat down, and I think we've come to a pretty good bill.
All right. Mr. Edge, anything you want to say?
No, sir, Mr. Chairman.
Any questions of the two people presenting? No questions? Oh, we do have one. Excuse me. Judge?
Thank you, Mr. Chairman. Same question that I had some time ago when I spoke with some of concerning this was where it says has no agent. Does this mean an office or a person who lives there, or what actually does the word agent mean?
I think, Representative Caldwell, I think agent is legally defined as someone who's authorized to take action on behalf of the company. So it wouldn't simply be an employee who happened to live in that county.
That's my point.
They would have to have some sort of authorization.
Or does it? Well, I'm not picking on. Please don't misunderstand.
No,
I have no problem with the bill. Just make sure when we talk about an agent, is this the executive vice president lives in Upson County as an example, and he doesn't. But I'm just saying if he does, and it happened there, could I then serve him or sue there? Or does it mean that it has to be a gas company office there?
No, sir. I think if they've got, if you can serve, if the cause of action arises in that county, you can serve one of two ways. You can serve the home office by second original, right, or an agent of the company, and that could be if for instance, you say an executive vice president, whatever, lived in Upson County, then I think you can serve that person because they have authority to act on behalf of the company.
It might have.
And it's case law, I think, dealing with who's an authorized agent for companies who
and this is current existing law.
Yes, sir.
We're not changing the current law. We're
That's
just
correct. Yes, sir.
adding the gas company as one of those entities.
That's right.
Okay. Judge, anything further?
No.
All right. Anyone else have questions? If not, we appreciate you being here. Is there anyone else who would like to address the committee? If not, we'll close off further public input, and House Bill 194 is in the breast of the committee. Is there any discussion within the committee? If not, the chair will entertain a motion. We have a motion to do pass by Mr. Jacobs. Second to it?
Second.
We have a second. Is there any further discussion? Are there any amendments? No amendments or discussion on the motion. The chair will call the main question, which is do pass. All in favor of passage of House Bill 194 signify by saying aye.
Aye.
Those opposed, like sign. If not, the bill passes. Thank you. Unamended. Next we have is House Bill 160 by Representative Jacobs. It's a bill entitled An Act to Amend Article 1 of Chapter 14 of Title 44 of the Official Code of Georgia relating to mortgages, conveyance to secure debt, and liens in general, so as to revise provisions relating to vacant and foreclosed property registries and to prohibit a fee for future conveyance except under limited circumstances.
Mr. Chairman, can I real quickly ask a question about the previous bill?
Yes, sir.
We passed that as a committee sub, didn't we?
It was a committee sub?
Yes.
It was. A substitute, yeah. Okay. I beg your pardon.
Thank you. It was only bill driven.
I didn't catch that. Thank you. Mr. Jacobs.
Thank you, Mr. Chairman. House Bill 160 is a reprise of the old House Bill 129 from the prior term that, as originally introduced, it became something of a Christmas tree or Hanukkah bush. During the legislative process, but as originally introduced, banned the recording of fees that run with the land for the benefit of the recording party, such that every time the land of the property that is that has this kind of fee attached to it is transferred, a fee has to be paid to the original recording party or his or her successors, heirs, or assigns. That practice of recording this sort of fee has been banned in more than 40 states at this point, and it was at the time the bill was introduced apparently more than 10, I think, but less than 20. So it's become a creature that needs to be banned in Georgia. Since that time, these recorded fees also have popped up in Georgia, and so the bill kind of takes on some increased urgency in that regard as well. It can contain exceptions for fees recorded by homeowners association, condo associations, property owner associations, and the like. That starts there on line 35 of the bill. I have also included in the bill a little bit of cleanup in section 1 of the bill to the old House Bill 110 from last session that did pass regarding vacant and foreclosed property registries. The two items that are being changed there are first of all, in the definition of the bill came back over from the Senate in take it or leave it fashion. And one of the things that was contained in the foreclosed real property definition didn't really make any sense for what foreclosed property is, and that's this language with regard to a land disturbance permit. So we are proposing to strike that language there on lines 13 and 14 of the bill, and then also that paragraph or subparagraph B. This deals with banks and foreclosing parties not having to register a vacant or foreclosed real property if they file the deed under power or deed in lieu of foreclosure within 60 days of the transfer of the property. Well, we simply use the word transfer. And then a lawyer who actually practices in this area contacted me in the off season and said, well, what did you mean by transfer? Is that the sale on the courthouse steps, or is that when the deed is transferred? Obviously, we didn't mean when the deed is transferred. In the case of a foreclosure sale, the only date we can really peg it to is the transfer, the deed in lieu of foreclosure. But in a foreclosure sale, we didn't mean the transfer of the deed. We meant the sale on the courthouse steps, which is an easier date to hammer down, and certainly was the intent of the General Assembly. So we're making that clear here as well. So that is House Bill 160, Mr. Chairman. Thank you.
All right, thank you. We had the bill last year, as I recall. I'm talking about Section 2, but it did not get through all the way. Is that correct?
Correct. And this, the language you see here, Mr. Chairman, in Section 2 is the exact language that was in the conference committee report that did not make the cut prior to the final day of session. Right. So this is the finalized language.
And nothing's changed from that time.
I'm sorry, we did strike some language in subsection A, just to make clear what a conveyance of real property is, but I'm very comfortable with the definition as we have it now.
Questions of the presenter? No questions? I have one. Has this happened in Georgia at this time? Is a in fact, ongoing occurrence where developers are putting these type of covenants to the property?
My understanding from practitioners in this area is that the answer to that question is absolutely yes.
Okay. And our bill won't affect those that already exist. It just will be, of course, ones that were tried for the future.
That's correct. And that that's is that clear in the Ms. Travis? Is that clear in the effective date language? I don't.
It doesn't have an applicability. It just has an effective date.
Mm-hmm.
If you want to add applicability, you can add that.
Can you actually just work up some language, make it applicable to instrument? I think it needs to be applicable to instruments recorded on or after the effective date of the bill.
Wait, speak up, I couldn't hear you.
Is instruments the right word?
I think your document.
Covenant.
You could look at lines 31, 32, and 33. I think that will be a good place.
The future, well, it talks about or other person, a fee in connection with a future transfer of the property shall be prohibited.
Shall be void and unenforceable. That makes it go to current.
Hold on, Ms. Galloway.
Yes, sir.
Well, no, because that really I think we need it in the effective. I think we need it in the effective date clause because that really deals with. I mean, you could have a covenant that's recorded now. Okay, I mean that really deals with the future transfers to which the fee applies. I think we can only have this be effective to instruments that are recorded, covenants that are recorded after the date of after the effective date of the bill.
I just thought that language could be ambiguous, so what you're suggesting would prevent that. Yes.
I think we'll get there.
Okay. That concludes the public discussion on the bill. It's now in the breast of the committee. Do we have a motion?
I'll move to pass, Mr. Chairman.
Motion is due pass and is seconded. Any discussion on the motion? Are there any amendments proposed? Mr. Chairman, you gonna make one?
Not an amendment, but I think Ms. Travers is looking like she wants to say something, and I'd like to hear what it is.
I'm looking at
I think one of of y'all need to make a motion. If she has some language you want to ask her for, you can do that. But do you want to make a motion to amend?
I do.
All right. State your motion.
Well, Ms. Travis?
Say what you want to be.
covenants recorded on or after such date? Is that what you're looking
After the effective date.
Well, such date. I'm adding that at the end of line 15.
Read it slowly to us.
I'm sorry.
I don't hear it fast.
Starting at line 59, this act shall become effective upon its approval by the governor or upon its becoming law without such approval, and shall apply to covenants recorded on or after such date.
There you are. Well stated. Everyone understand the proposed motion?
Well, and all right, hold on.
If you got another motion, we'll do that if we get this one.
No. It's this one. I think we should probably add to that to make that particular clause that you just stated applicable only to Section 2 of the bill. Okay. Yes.
You're going to now have to divide it up, I believe.
No.
You're not? Okay.
After the word approval on line 60, and section 2 of this act shall apply to covenants recorded on or after such date.
There you go. Everyone understand the motion? And the motion to amend. Any discussion, further discussion on the motion? If not, the chair will call the question. All in favor of the motion to amend signify by saying aye.
Aye.
Opposed, like sign. Motion carries. Any further amendments to LC 295446?
I have a question, Mr. Chairman.
We have a question, discussion on the motion. Yes, sir.
The earlier legislation that Mr. Hightower had dealt with covenants and the fact that covenants expire after 20 years. So even if we cannot retroactively come back and stop these covenants, will they expire after 20 years?
I don't know that you have a provision in the law dealing with real property covenants that provides for covenants still go for 20 years, but there is a provision that says unless those covenants are removed by action of either all or majority, I can't remember what it is, of the properties affected by the covenants, they automatically renew. So I'm not totally clear. Subdivision. Right. Thank you. Yeah. So I'm not really sure to answer your question. Any further discussion? If not, the chair will call the question. The motion is to approve pass House Bill 160 as amended as a committee substitute. All in favor of the motion signify by saying aye. Aye. Opposed, like sign. Thank you. Judge Osborne, I forgot to recognize you, so I waited. Be sure you stayed all the way through with us. Judge Osborne from Newton County, we're pleased to have you with us. Anything you'd like to say to the committee? We're always honored to have the judiciary come spend some time with us. Thank you, sir. Well, thank you. We always usually have good discussion. Got some pretty easy ones today. Anyone else have a comment? I want to give you some scheduling of what we're doing. Monday morning, Mr. Jacobs will have a subcommittee meeting at 9 o'clock. You are having what bills again? HB 1?
That's House Bill 1, the forfeiture bill. That's up hearing only. And then Representative Bruce's bill dealing with mugshots will be, that's House Bill 150 will be on the agenda as well. And we have today filed the new juvenile code bill, the rewrite, which included the governor's criminal reform commission, criminal justice reform, thank you, I'll get it all together, recommendations, and that bill is now open. We don't have a number, but I'm going to send out a statement in the morning. You have number? 242. Thank you. It is House Bill 242, and we anticipate next Friday, after everyone has had a chance to review, digest it, we're going to start a hearing at 1 o'clock on Friday and go probably till 5 o'clock, if necessary, to have opportunity for everyone to address the committee on that bill. This is one of the most important things we've done in the last couple of years, so I think it's fitting that we do have it. It's going to be a full committee hearing in the entire time on the bill. No subcommittees.
Friday the 17th, Mr. Chairman?
Yes, sir.
Upon adjournment, we will have a hearing.
Starting here at 1 o'clock. Yes, sir. Only that bill.
Are we in session next Friday?
Well, we're not?
It's President's Day weekend.
Friday and Monday we are not.
You're in Monday through Thursday next week.
That's right. What time we get out Thursday? Probably early? Well, let's move back then. We'll move that back, and I don't ask anybody to come back from out of town, so we're going to try and do it on Thursday afternoon at our regular time, which will be probably 2 o'clock. If we get started earlier, I may do that, but for the moment, just recognize we're going to have a hearing starting next week, at least that day, for only the juvenile code rewrite. Anyone wants to state the committee? If not, we're thankful for all of you being here today and enjoyed having you, and we'll see you next week. We'll stand adjourned.